I'm Jane Roberts, Development Control Manager, and I've been working in planning since 2003 and for the state since 2008. This evening I'm here to talk to you about the best way to have your say on planning applications. If you've previously made representation and engaged with the planning service, it's likely that this would have been in relation to a planning application. However, as we've heard from Claire and we'll hear from Jim this evening, there are other avenues by which you can have your say, and we do hope that you use the opportunity to contact us in these ways too. So what I'm hoping for this evening is that you leave here knowing how you can contact us, why it is important, and what you can include and what you can expect if making contact with us on a planning application. So, sometimes people consider that it's better if you get an advocate or person of standing to act on your behalf. However, this is false. Although it is your choice to use a third party, all letters, providing they relate to matters that can be considered as planning material considerations, are regarded the same despite who has written them. Letters don't get read by the planning officers. False. All letters are read, however, only certain things can be taken into consideration. The more letters that are written, the better chance there is of the application being refused. False. The application will be considered in light of all representations, purposes of the law, IDP policies and material planning considerations. A decision is not based on the number of representations. You can only make representation if you live near the development. False. Representation can be received from any islander. However, again, the content must be relevant to the development and relate to planning matters. All letters are confidential. False. Letters of representation are confidential up until a decision. Once a decision is issued, the applicant or agent can request copies of any letters received. Representation can only be made in planning form. True. Voicing your views in person or over the phone can't be taken into account. So when can you make representation? The majority of applications are advertised by site notice. A site notice will show the date on which it was put up, and this should be in place to which the public have access. Although we do try and carry out site visits to the property during the time that the site notices should be up, if for any reason you feel that a site notice doesn't meet these tests, then it is open to you to let the planning service know. We can then, if needed, look into this further. At the moment, planning applications are also published in the press every Tuesday, and a register of valid planning applications is available online at www.gov.gg and by following the link Planning and Building Control Applications and Decisions, comment or object to a planning application. Representations can be made on any valid planning application, but to make sure that it's taken into account when deciding that application, your letters or emails normally have to be made within 21 days of the display of the site notice. What method can you use to make your representation and what should be included? At the moment, contact with the planning service can be by email or post, but it must be in written form. As an aside, we are looking at digitising the service, so this may change in the future. The standard email address in which to send emails is planning@gov.gg, or for the attention of the planning service at Sir Charles Fossard House if using traditional mail. Any letters or emails must, as a minimum, include your name, your address, application number or address to which the representation relates. It is important to include your name and address so we can understand the relationship to the application site and, more importantly, so we can contact you. What can you expect when you submit your representation? Well, by contacting us by email, in this case, two things: a standard acknowledgement from the planning service email address as seen on the screen, and also a letter via the post. When submitting your comments via post, you should expect to get an acknowledgement letter, also by the post, as now displayed on the slide. The acknowledgement letter will note receipt of your letter or email, advise that you will be told of the decision when made, that only material planning considerations can be taken into account, and civil matters such as boundary disputes can't be considered. But I should also say that the approval of a planning application on a neighbouring site doesn't mean that works can be carried out to your own property without your permission. The acknowledgement letter also advises that your letter of representation is not confidential once a decision on the application has been made. However, I would like you to note that letters or emails are only sent to applicants or agents following a written request by them and are not sent out as a matter of course. So, what can be taken into account? This depends upon the development applied for and the constraints of the site, but for all applications, only what are referred to as material planning considerations can be taken into account. Material planning considerations are made up of the purposes of the law, any development plan, subject plan or local planning brief, material planning considerations and material considerations for protected monuments, buildings and trees. Why can the planning service only consider certain aspects, and how are the representations perceived by the planning service and how are they used? The things that can be taken into account in any planning application have to be relevant to the planning decision. Material planning considerations look at things that can be taken into account when making a decision on a planning application. They are used to make sure that standard items are thought about to make sure that the decisions made are sensible and based on assessment, not personal belief and preference. General material considerations as such include effect on natural beauty and landscape quality, as shown by the top right-hand picture, the character and quality of the natural and built environment created, the appropriateness of the development in relation to its surroundings, again as shown by the bottom picture, effect of the development on the character and amenity of the locality, effect on roads and other infrastructure, effect of the proposed use and that to which it could be put, any planning covenant which would have a material connection with the development, effect on parks, playing fields and other open spaces as shown in the top picture, and effect on the reasonable enjoyment of neighbouring properties as the bottom diagram is hopefully showing. We certainly don't want to be encouraging the bottom diagram. These general material planning considerations are also mirrored within the policies contained within the Island Development Plan. For instance, taking the second bullet point previously shown on screen, that being the character and quality of the natural and built environment to be created by the development, this is mirrored in IDP policy GP8 design, which looks for new development to respect the character of the local built environment or the open landscape concerned. It is important to understand, though, that appropriate material considerations in relation to any individual application need to be weighed against their seriousness and relative importance in the final decision-making process. Your views on any application form a core part in the life of a planning application and are seen by DC officers as a normal part of the application process. If an application is to be heard and decided at an open planning meeting, writing in on a planning application also means that you then get the right to speak at the open planning meeting or for you to ask somebody else, such as a deputy, to speak on your behalf. You are only able to speak at an open planning meeting if you have already written into us on that application. All comments we receive about planning applications are looked at, but only those which raise the material planning considerations, as noted on the screen, can be taken into account when deciding an application. An assessment by the planning officer, taking into account all relevant information, is then carried out, and all relevant points are weighed up and balanced against the different factors. Following this assessment, a recommendation of a decision is then made. Why a certain decision was made on an application has to be justified in relation to these material planning considerations. Decisions based on non-material considerations, such as impact on property value, would not be allowed and would be open to legal challenge. Can you have help in making your representation? Yes, very much so. Advice on how to make comments on a planning application is available online at www.gov.gg, and a Development Control Duty Planning Officer is available Monday to Friday between 9 a.m. to 5 p.m, either in person at Fossard House or on the phone. But although we are more than happy to help point you in the right direction to advice and also give you advice, we can't and won't tell you what to put into a letter. We are not the best place to decide how the development is going to affect you. So although we will advise as much as we can, it is important that it is you that writes the letter and that our role remains detached and not seen to be offering favouritism to any party. How do you monitor what is happening and what happens at the point of decision? What should you be expecting? Information in relation to what is happening with an application is available online through the planning web search. To be able to use this, you will need to know the relevant application number and/or the address of the property. An application progress bar is available to view as shown on the slide, which is to the left-hand side. If you don't have access to the net, our tech support team can also provide an update. But the information that they will be able to share with you is limited to whether the application remains pending. If you have made comments on an application, though, you will be told either of the decision made or informed that the application will be decided at an open planning meeting instead, and this will be done by letter via the post. The letter, as seen on screen, provides a link to the website as well as other additional information. This provides access to the officer's reports and the decision notice, including any attached conditions. So where can you find additional information? Shown on screen is the address to the website and several useful links to obtain relevant information. I do also have some hard copies of guidance available this evening, but these will be on a first come first served basis, so if anybody does want any at the end of the session, just let me know. In addition to our own guidance, guidance on material considerations is readily available on the net. Although not directly relevant to Guernsey legislation or Guernsey planning law, some useful information can be obtained from the UK Government website, also displayed on the screen. Thank you for listening and for your time this evening.